much, Jeff. Good morning, everyone. Happy Friday. Thank you for joining today, this morning's webinar on the SIRS milestone inspections, the legal requirements. This webinar is being provided by Kaye Rembaum, attorneys at law. Today's presenter, Kerstin Henze, she is the firm's managing attorney. Sorry, wait. You're the firm's managing attorney at your Tampa office. We've done many a webinar together. I agree with Jeff's comments about walking encyclopedia. Thank you so much for providing today's course on the milestone SIRS. So GRS, I work for GRS Community Management. I'm the corporate trainer over at GRS. I'm also a licensed community association manager and board member at my community association. GRS is a mid-sized management company located in Lake Worth, Florida. We provide great, reliable service to over 240 communities all across our state. We've been in business since 1989. You can follow us on Facebook, LinkedIn, X, Instagram for more information on future webinar presentations and more information on our services. If you would like an additional information regarding our services and property management, or our CAM that is looking to make a change, go over to our GRS website at grsmgt.com. Again, thank you all so much for coming to today's webinar. Kerstin's going to be going over the SIRS milestone inspections. I think you're also going to be covering some of the new legal updates to those items. They're minor changes, but this is a great course for condo associations, condo association managers. So definitely take some notes. I know it's a lot, especially in addition to all the recent legal updates. So without further ado, I'll turn it over to Kerstin and let's get started.
Great, thank you, Courtney. Good morning, everyone. Thanks for joining. My name is Kerstin Henze again. I am the managing attorney for the West Coast office of the firm located here in Tampa. I've been practicing law for 16 years and I've been with the firm since 2010. So without further ado, let me share my slides for today. There's a lot of information on these slides, but they will be made available at the end of the class, okay? I'm going to try not to read through the slides, okay? There is a lot of information. I will be touching on a couple of updates to the SIRS that was in House Bill 1021 that was recently signed by the governor. All right, but let's start with the milestone inspection. All right, so who needs to do the milestone inspection? Just make an adjustment here. Sorry. Okay, so the milestone inspection applies to any owner of a building that is 3 stories or more in height as determined by the Florida Building Code and is subject in whole or in part to residential condominium or cooperative form of ownership. Okay, so if you are condominium or a co-op association and you have buildings that are at least 3 stories or more in height, as determined by the Florida Building Code, you are required to do your milestone inspection. Now, whether your particular building is 3 stories or higher, again, for most of you, it's probably easy to determine. For others, you'll have to obviously confirm with your engineer or architect whether your building fits this requirement. The milestone inspection also applies to any residential mixed-use and condominium hotel buildings, okay? What the milestone inspection does not apply to is purely commercial buildings, okay? It also does not apply to single family, 2-family, 3-family, or 4-family dwellings with 3 or fewer habitable stories above ground. Okay, the 4-family dwelling was just recently added in House Bill 1021. This will become effective July 1st. Okay, what is a milestone inspection? Well, the statute defines it as a structural inspection of a building, including an inspection of the load-bearing elements and primary structural members and primary structural systems. Okay, so it no longer includes just load-bearing walls. It's load-bearing elements. This was a change in the statute last year. Now, the milestone inspection has to be performed by either an architect or an engineer licensed in the state of Florida, or this was a change to the statute last year. The milestone can also be performed by a team of professionals with one of them acting as the registered design professional. Okay? This was a change last year that was made in order to meet the demands of shortage in the labor force, right? Too many condominiums need to get this milestone inspection performed, not enough engineers or architects to do that, okay? So now you can have a team of professionals assist you with milestone inspection. Now, what is the purpose of the milestone inspection? It is only to attest to the life, safety, and adequacy of the building's structural components, and to the extent reasonably possible, to determine the general structural condition of the building as it affects the building's safety, including a determination of any necessary maintenance, repair, or replacement of any structural components. Okay. What the milestone inspection is not intended to do, okay, is to determine the condition of the existing building and whether it complies with the Florida Building Code. So the milestone inspection is not going to confirm whether or not your building is in compliance with the Florida Building Code. It's also not intended to identify surface imperfections, such as cracks or sagging or misalignments. Unless, of course, your engineer or your architect, whoever's performing your milestone inspection, determines that that surface imperfection is a sign of a substantial structural deterioration. And that is a defined term in the Florida statute. So what a substantial structural deterioration is, it's a substantial structural distress or substantial structural weakness that negatively affects a building's general structural condition and integrity. And that's going to come up later on in the slides when we're talking about phase 1 and phase 2 requirements. Okay. So when do we need it? All right, so if you are an association with buildings, at least a building that is 3 stories or higher is determined by the Florida Building Code, okay? You have to complete your milestone inspection by December 31st of the year in which your building reaches 30 years old. That's from the date of the certificate of occupancy of the building, and then every 10 years thereafter. Okay, so the deadline is December 31st of the year in which your building reaches 30 years of age. That's measured from the date of the certificate of occupancy. If you don't have a certificate of occupancy available, then it's the date of occupancy that's evidenced in any record of the local building department. Now, if your building reaches 30 years of age before July 1st of 2022, then your initial milestone inspection has to be performed before December 31st of 2024. If your building reaches 30 years of age after July 1st of 2022, but before December 31st of 2024, then the building's milestone inspection, the initial one, has to be performed by December 31st of 2025. Okay, so those are the initial dates that have been set forth in the statute. There have been no extensions to these dates. Now, if you've completed a milestone inspection or an inspection or similar local government requirement, and that was performed within the past 5 years, which meets the requirements of the milestone inspection, then you can use that inspection as your visual inspection portion of the structural integrity reserve study. Okay, so again, if you've done your milestone inspection, or if, for example, your county requires or has established a different type of inspection program, for example, Broward County has established a 25-year safety inspection program. If you've done an inspection pursuant to your local county requirements, okay, and that was done in the last 5 years, then that could be used as your visual inspection portion of your SIRS, provided it meets the statutory requirements. Now, that 30-year timeline, of course, can be modified by your local enforcement agency. So they can require you to complete your milestone inspection in less than 30 years, 25 years, okay? So they can require you to do your milestone inspection by December 31st of the year in which your building turns 25 years old. This has been done by at least one county, Broward County. Now, this requirement replaced an older provision in the statute from last year that that addressed buildings within 3 miles of the coastline. Okay, so in lieu of that, now the statute provides that a local enforcement agency may also extend the initial due date for the milestone inspection upon a showing of good cause that the inspection cannot be timely completed if the owners of the building have entered into a contract with an engineer or an architect. So as long as you have at least entered into a contract with an engineer or an architect, okay, you can potentially get an extension. You can't meet the deadline requirements. Now, a local enforcement agency can also accept an inspection report prepared by an engineer or an architect for your SIRS or any other type of inspection program, okay, that was performed before July 1st of 2022 if that report substantially complies with the requirements of the statute. Okay, so it's giving you a little bit of flexibility there. Now, you still need to comply with unit owner notice requirements for that report that's set forth in section 553.899 of the Florida statute, and we'll talk about those in a minute. Those relate to the notice requirements that if you, once you received your milestone inspection report within 45 days, you have to disseminate copies to the membership. So I'll talk a little bit more about that requirement in a minute. Okay, if that inspection report is accepted by your local enforcement agency, then it will be deemed as your milestone inspection under the statute. And if a previous inspection and report is accepted by your local agency, then the deadline for the building's subsequent 10-year milestone inspection will be based on the date of the accepted previous inspection. Now, again, the milestone inspection report has to be arranged by your condominium or cooperative association or any owner of any portion of the building which is not subject to the condominium or co-op form of ownership. So again, this still applies to mixed use and condominium hotels. Okay, each of these parties are responsible for ensuring compliance and for the cost associated with the performance of the milestone inspection. Now, upon determining that your building has to do a milestone inspection, okay, your local enforcement agency is required to provide you with notice that you're due for that inspection. Okay, So the local agency has an obligation to provide you with notice that you're required to do the milestone inspection. Once you receive the notice from your local agency, then you have an obligation. The association then has to notify the owners of this notice. You must provide your unit owners with a copy of this notice from the agency within 14 days after receiving the notice. Okay. And then the notice also has to let the membership know the date by which the milestone inspection must be completed. Okay. Now, completed, the term completed is defined in the statute, and that means when your engineer or architect has submitted a copy of the inspection report to the local enforcement agency. Now, phase 1 of your milestone inspection has to be completed within 180 days after you receive that notice. Now, note that this is the maximum requirement on the statute. You have 180 days. It's quite possible that your local enforcement agency might require you to complete your phase 1 inspection in less than 180 days. We've seen that with Broward County, where they've required condominium associations to do their milestone inspection within 90 days. Okay, so it's very possible that you might get a notice from your local agency to complete your milestone inspection in less than 180 days. Now, phase 1 of your milestone inspection. This is a visual examination, okay, that's going to be performed by your architect or engineer of the habitable and non-habitable areas of the building, including major structural components. Now, only if your engineer or architect discovers that there's substantial or determines that there's substantial structural deterioration, only then will you have to move on and undertake the phase 2 of the milestone inspection. So if your engineer in his report finds no signs of substantial structural deterioration, as the term was defined in an earlier slide, then you are not obligated to do the phase 2 of the inspection. Again, phase 2 only needs to be completed if there's substantial structural deterioration. Now, phase 2, if your engineer determines that's necessary, can involve destructive or non-destructive testing. That's at the discretion of your engineer or architect. And the inspection can also be as extensive or as limited as necessary to confirm the building is structurally sound. Okay, that's going to be at the discretion of your engineer. Now, if your phase 2 milestone inspection is required, okay, while there's no deadline by which phase 2 has to be completed, within 180 days after submitting the phase 1 inspection report, your architect or engineer will have to provide a progress report to your local enforcement agency with a timeline for completing the phase 2 inspection. Okay, and that's within 180 days after submitting the phase 1 inspection to your agency, to the local enforcement agency. So in addition to submitting a completed copy of your milestone inspection report to the local enforcement agency, your architect or engineer, whoever performed your inspection, also has to submit a sealed copy of the full inspection report along with a summary, okay, to the association. And the statute provides for what that report needs to include. Among other things, it has to identify any substantial structural deterioration and recommend any repairs. Okay, so you should be receiving not only a copy of the full inspection report, but also a summary of the report. And that's regardless of what the determination of the engineers in the report. Okay, once you receive a copy of the inspection report from the engineer with the summary, you have notification requirements. So the statute requires the association within 45 days after receiving your inspection report to do several things. Okay, you have to distribute a copy of the summary to all the owners. Okay, the copy of the summary can be provided by U.S. mail, it can be hand delivered, or it can be emailed to those owners who have consented to receiving notices by electronic means. You then have to post a copy of the summary in a conspicuous place on condominium or association property. And then you also have to publish the full report on the association website. Now, come July 1st of this year, there's going to be new requirements for associations to have websites. Okay, so just be mindful of that if you're not presently required to have a website, you might be after July 1st of 2024. The statute also provides that the Board of County Commissioners or your municipal governing body can also adopt ordinances requiring that repairs for substantial structural deterioration commence within a specified time frame. Okay. However, these repairs must be commenced no later than 365 days after receiving the report. So that is the maximum time frame within which these repairs have to be made. You have to make any. But again, be mindful, your local municipal governing body may adopt an ordinance providing for other timeframes for you to commence repairs. If the association fails to submit proof of repairs, then the local government must review and then can determine if the building is unsafe for human occupancy. Okay. So that was on the milestone. Let's jump into your structural integrity reserve study. Slide. All right. So again, if you're a residential condominium association, you have to perform a structural integrity reserve study at least every 10 years. And this applies for condominiums that are at least 3 stories or higher, as determined by the Florida Building Code. And the study has to be of the following items. It has to include the following items: roof, structure, including load-bearing walls and other structural members, fireproofing, fire protection systems, plumbing, electrical systems, waterproofing and exterior painting, windows and exterior doors. And again, this was a clarification in last year's statute. We're only talking about windows and exterior doors that the association is required to maintain under its governing documents, not windows and doors that owners are responsible to maintain and replace. And then the last item that your SIRS has to include is any other item that has a deferred maintenance expense or replacement cost that's over $10,000, and the failure to replace or maintain that item will negatively affect the other items listed in the SIRS. So for example, that could include an elevator, or that could include a seawall if you have a seawall. Okay, while the statute does not specifically identify those items, okay, if the cost of maintaining or replacing those items will exceed $10,000 and failure to maintain or replace them will negatively affect the other items, then they'll have to be included in your SIRS. Okay, that's a conversation you're going to have with your engineer. the structural integrity reserve study is based on a visual inspection. Okay, and at a minimum, the study has to identify each item of the condominium property that's visually inspected. It has to provide the estimated remaining useful life and the estimated replacement cost of the SIRS item. And then it has to provide a reserve funding schedule with the annual reserve amounts that will be necessary in order to achieve the estimated replacement cost. So really, these items here that I've identified on the slide, they're really no different than what is required or has been required for your non-SIRS statutory reserves. Okay, so whether you're a building that's not required to have SIRS, or even if you are required to have SIRS, prior to this, you were required to fully fund your typical reserves under the statute for your roof replacement, your painting, your paving, and then any other deferred maintenance or replacement item that would cost more than $10,000. So again, this is the same schedule as you have been doing for your non-SIRS reserves. Now, with regard to those items with an estimate of useful life is not readily ascertainable, or with an estimated remaining useful life of greater than 25 years, the association is not required to reserve replacement costs for those items, but the association must reserve the amount for the maintenance expense, if any, which is recommended by your engineer. Now, the SIRS does not apply to the following. Okay, if your building is less than 3 stories in height, these requirements do not apply to your association. Single family or 2-family, 3-family dwellings with 3 or fewer habitable stories above ground, or any portion or component of a building that has not been submitted to the condominium form of ownership. It also does not apply to any portion of the building that is maintained by a party other than the association. Okay, so again, back to the example of the windows and doors. If owners maintain it, then the SIRS would not include those items. And then it also does not apply to commercial condominiums. Now, who can perform the SIRS? The structural integrity reserve study can be performed by any person who's qualified to perform the study. However, the visual inspection portion has to be performed by either an engineer or architect licensed in the state of Florida, or any person that is certified as a reserve specialist or a professional reserve analyst by the division. All right, deadlines for completing the SIRS. If your association has been in existence on or before July 1st of 2022, okay, which is unit owner control, then your SIRS has to be completed by December 31st of 2024 for each building that is at least 3 stories or higher. Now, the statute does provide that an association that is required to complete a milestone inspection on or before December 31st of 2026, they can complete their SIRS simultaneously with their milestone inspection. However, in no event can the SIRS be completed after December 31st of 2026. Okay. There have been no other extensions to this deadline in the recent bill that passed. Now, the association can adjust the replacement reserve assessments annually to take into account any inflation adjustment, as well as any changes to an estimate or extension of the useful life of a reserve item. You can adjust for inflation. Okay. And I've added the slide here, even though it was in a prior slide, that again, if you did a milestone inspection or an inspection completed by your, that was required by your local enforcement agency within the last 5 years, that inspection can be used in place of the visual inspection portion of your SIRS. So you can then take that visual inspection report and have your reserve study completed. All right, here's one of the new changes to the statute, and this will become effective July 1st. So the governor just signed House Bill 1021, which affects condominium, I believe, what, two weekends ago or 2 weeks ago, June 14th, I believe. So, but this will become effective July 1st. So within 45 days after receiving your SIRS, the association has an obligation now to distribute a copy of the SIRS to the owners or deliver notice to the owners that the study has been completed and available for inspection and copying upon written request. So you're given 2 options. You either provide a copy of the study or notice of its availability. The copy or the notice can be sent by mail, hand delivery, or it can be electronically transmitted by email to those owners who have consented to receiving notices by email. And then in addition to this requirement, you also have the obligation within 45 days after receiving your SIRS to provide the division with a statement indicating that the study was completed and that the association has provided or made the study available to the owners. Now, the statute does say that this statement has to be provided to the division in the manner established by the division using a form posted on the division's website. Now, I'm not aware that the division has yet created this form on the website. It's not since I last checked. So just be mindful that, again, the division will hopefully soon be posting some form on its website that you will need to complete. Now, of course, the statute is not clear whether this applies to those associations that have already completed their SIRS before July 1st of 2024. It would have been great if the legislature would have just added one sentence to that effect, but there's no clarity about that in this legislation. So, I mean, as a practical matter, and to avoid potential issues with owners complaining to the division, this requirement seems innocuous enough that you might want to provide notice or a copy of the study to the owners. Okay, what else with SIRS? Slide. Okay. So waiving and reducing reserves. So remember, we've been talking about your SIRS reserves, but don't forget that associations still have the obligation to fund non-SIRS reserves. Okay, and certainly if you are under 3 stories, okay, that obligation has not gone away. Okay, so if you maintain non-SIRS reserves, and you're not required to maintain SIRS. For non-SIRS reserves, you still have the option to waive or partially fund the non-SIRS reserves with membership approval. The membership approval requirement did change last year, and the vote that you would need to get is a majority vote of the total voting interest. So it no longer is a vote of a majority of quorum, which was a much lower threshold. So again, for non-SIRS reserves, you still have the option to waive or partially fund them with the approval of a majority of your voting interest. But those associations that are required to do to fund SIRS reserves, okay, for budgets adopted on or after December 31st of 2024, you will no longer have the option to waive or partially fund those SIRS reserves. Now, that's if you adopt the budget, that's for budgets adopted after December 31st of 2024. So if you are not in a position to fully fund reserves yet, and owners vote to either waive or partially fund your SIRS reserves before December 31st of 2024, and the board then adopts that budget with waived or partial funded SIRS reserves before December 31st of 2024, then you don't have to fully fund them in the 2025 budget. So the fully funding of your SIRS reserve in that case would start in the 2026 budget. But that's again, only if you get your membership by a vote of the majority of the voting interest to waive or partially fund those reserves before December 31st of 2024, and then the board adopts the budget before December 31st of 2024 with those waived or partially funded reserves. All right, another change in the statute that will become effective July 1st of 2024. If the local building official determines that the entire condominium building is uninhabitable due to a natural emergency, that the board can then, upon the approval of a majority of its members, pause the contribution or reduce reserve funding until the local building official determines that the building is habitable. Okay, so that would only apply again if your local building official condemns your building essentially. The statute also provides that any reserve accounts, any reserve funds may be expended upon the board's determination to make the building habitable. So it seems like you won't need to get a membership approval to use these reserve funds for these alternate purposes. And then upon the determination of the building official that the building is again habitable, the association must immediately resume contributing funds to its reserves. Again, it's unclear whether this applies to SIRS reserves. Presumably it does. All right, using reserves for alternate purposes. For non-SIRS reserves, associations still have the option to use those reserves for alternate purposes, for purposes other than for which they were originally intended, but again, provided you obtain the vote of the owner. And the vote that you need to get would be the majority, the vote of the majority of all the voting interests. Again, it used to be that you needed a vote of the majority of quorum. That's no longer the case. The vote you need now is a majority of the voting interest to use your non-SIRS reserves for alternate purposes. For SIRS reserves, again, for budgets adopted on or after December 31st of 2024, you're no longer going to have the option to use SIRS reserves for alternate purposes. Okay. So if you have SIRS reserves for your roof replacement, you will not be able to use those to fund a shortfall for any other purpose. All right, pooling generally. For those associations that currently maintain reserves in a straight line method, if you wanted to have the option of pooling those reserves, generally to go from straight line to pooling method does require a vote of the owners, and the vote that you need to get is a vote of the majority of the voting interest. Now, you can pool your non-SIRS reserves, and you also can pool SIRS reserve items. You just cannot pool those together. You cannot have a pool of SIRS and non-SIRS items in the same pool. Now, whether you have to get membership approval to pool any of your SIRS reserve items, I mean, that's something that you'll have to speak with your legal counsel, depending on how you've been maintaining and really, you know, what reserve items you want to put in the pool and where are you getting them. And so those are going to be very specific to your association to speak with your legal counsel as to whether membership approval will be necessary in that case. All right, and then effective July 1st of 2027, the term dispute in the statute will now also include the failure to obtain milestone inspection, the failure to obtain a structural integrity reserve study, failure to fund reserves, and failure to make or provide the necessary maintenance or repairs of your condominium pursuant to your milestone inspection. All right, so that is a dispute that any owner can pursue. However, these disputes, okay, as mentioned here, these 4 items, they're not subject to mandatory non-binding arbitration. They have to be submitted to pre-suit mediation, and if it's unresolved, then litigation would have to be addressed through litigation. Okay, so the association's failing to do any of these items, an owner can send a letter of pre-suit mediation, and hopefully the issue will be resolved then, and if not, it can proceed to litigation. All right, and then I've also provided here a brief summary of the owner disclosure requirements for prospective purchasers with regard to your milestone inspection and the SIRS. So if you're a unit owner and you're looking to sell your condominium unit, you're now required to provide prospective buyers copies of the Milestone Inspection Report and the Structural Integrity Reserve Study, or notice that such reports have not yet been prepared. And this has to be provided at least 3 days prior to the execution of your purchase sale contract. If the reports are provided thereafter, the buyer then has 3 days to rescind the contract. In addition, the purchase sale contract that does not conform to these requirements are considered voidable at the option of the purchaser prior to closing. There's also some developer requirements to now provide the SIRS as part of turnover. So the developer requirement to provide the SIRS as part of turnover has been deleted and then replaced with a requirement that the developer must have a turnover inspection report done in compliance with these statutes. Okay, and while I'm not gonna read through these, I've provided them for you in case you're in a condominium that is looking to turn over very soon. These are the items that the report has to address.
Again, thank you so much, Kerstin, for the presentation. It was very informative, great on time. Jeff, again, thank you for organizing this presentation. So I'm the corporate trainer. Once again, I'm the corporate trainer at GRS Community Management. We are a mid-sized management company based out of Lake Worth, Florida. We handle all any condo association, co-op, HOA association management. We provide accounting services as well. If you are interested in getting a proposal for a community, or you're a CAM interested in a change, you can visit our website at grsmgt.com for more information. My direct contact, you can, of course, email me. My direct contact is my direct phone number is 561-941-4220, and then my email is cbuchan@grsmgt.com. Again, thank you so much for everyone that joined today's presentation. We try to offer more of these webinars to our boards and residents and community managers. So you'll see those on our social media accounts and our website. So thank you once again. Kerstin, I'll turn it over to you for your information.
Thank you. Again, everyone, thank you for joining me today. Thank you, Courtney, for the opportunity. Thank you, Jeff. I can be reached by email, which is here available on the screen, or you can call the main number of the office in the Pompano Beach office, 954-928-0680, and your call will be routed to me. Thank you all.